Welcome. My name is Ali Goff. I'm the owner and founder of Goff Legal, and we do estate planning for clients throughout California. Now, you may have heard about a new law that was passed, and it's effective April 1st, 2025. So, the new law was designed to let families inherit homes without the grueling process of probate. Sounds great. I'm excited. I was loving it. I was really excited for clients until I realized the things it did and didn't do. I'm going to share with you some of the things you need to know about this particular law so you can decide what you want to do with that information. So, if you've recently lost a family member or someone who owned real estate in California worth less than $750,000 and they have cash assets worth less than $200,000, you can take advantage of a court proceeding called a small petition for succession to determine real property. Petition. Don't worry about it. We're going to file a petition. What this will do is allow people, if everybody's on board and signs off, they can transfer the real estate without a full-blown formal probate. Sounds good. Loving that. Excited for the options. So again, remember, has to be a primary resident worth less than $750,000. You need the probate referee in the county to appraise the property, certifying that. You can't just go on Zillow and you can't just guess. And you don't get your real estate agent and don't pay any other appraiser to do this because it has to be the probate referee in that county do an appraisal, and you'll file a petition. One of the things you need to know about this is you also have to have cash investments, any other accounts in their name worth less than $250,000. If the house is worth more, if the cash is worth more, if both are true, you're off to regular probate. This will not work for you. Don't bother. If those things are both true, then you file a petition with the court that says all these things are true, and you agree to assume the debts of the decedent. If you move forward with this procedure, you will get the assets, but you're also personally responsible for all of the debts of the decedent. Did you hear me say that? You're responsible for it. So if they have a lot of money that they're owed to someone else, and all they had was this house, and you decided to use this procedure and inherited it, you have to personally pay those debts when the creditors come calling. Probably not really fun. If you can pay them, that's great. But if not, you're probably going to have to sell the house to do that. The other thing about it is it's still going to be a process. There's still a petition. There's a filing fee with the court. There's a waiting period. It's not a magical, we're done really easily. There's a process that needs to be gone through. And so a lot of people thought, hey, this is going to change the way we do estate planning fundamentally. We're not going to need trusts anymore. We're going to be like the other states. California's been very trust heavy, meaning most of our estate plans include trusts. Why? Because that's the most efficient mechanism whereby we transfer real estate and other assets to heirs and family members and beneficiaries. This isn't really going to necessarily change the way we do things because I was looking up some median house prices in our local area, and the median house price in Loomis is over $1 million. Granite Bay, 1.1. Roseville, I think it was in the 600s or something like that. Placer County, I think it was like 650 median house price. That means many houses are far in excess over $750,000. The other interesting thing is that 750 does not adjust for inflation. So next year, it's not like, oh, if the house went up in value, so did this cap. It's still at 750. So you're going to have to guess, hope, pray, whatever you want to do, that it goes less than $750,000 to what? Avoid a trust? I'm just telling you. Trust planning is still one of the best things you can do for so many different reasons. But it's also important to know that this is an additional tool in our toolbox. So if someone passes away and they didn't get their trust done in time, that doesn't mean a hope is lost. It doesn't mean we're going to go through probate with all the statutory fees, but you're going to have to come out of pocket to pay the lawyer to get this done, to make these transfers, to do all the court proceedings. It's better than it was, but it's still not phenomenal, still not fantastic. But it is a resource. So if you are dealing with this, you can contact our office, info at Goff Legal, or through our website, gofflegal.com, and see if we can support you. If we can't, we have some phenomenal resources that we can point you in the right direction. If you'd like to avoid this procedure, come see us and we'll get your trust-based estate plan done. We will create a trust for you, and you don't even have to worry about this law or inflation or anything else, because everything you own will be protected from probate and no one will have to worry about it because it will all be done far in advance. So that's the update on the new law. I hope that was helpful. And gofflegal.com, like I said, if you want more information.